Good morning. Okay, this is a quick case study share of something that happened recently and how you can absolutely kill your case despite being disabled medically and proving it. If you don't follow directions, stick in the rules, meaning listen to your lawyer and keep them informed of everything you're supposed to keep them informed of. Okay, so here's the situation. Person comes to the attorney wanting to appeal a denied initial application. This is back in 2021. Attorney is going to agree based on everything that they know medically. They do find out, the attorney finds out that the person has gone back to work part-time. This is after some major cardiac events. And there's a lot of medical impairments related to that and slightly separate from that too. So the person's going back to work part-time because a lot of times, particularly for single people that don't have a working spouse or partner, how are you going to pay your rent or your mortgage? If you have pets, how are you going to take care of them? I mean, there's so much, utilities, whatever the case may be, that, life costs just to live, unless you maybe live out in the woods and hunt your own food. So this person went back to work part-time. Obviously that their rent was so high, and where we choose to live obviously has a big impact on that. That's a video for another day, but people really need to start being prepared financially for plan B, which means like the longer haul of a case. But anyway, so going back to work part-time, he still wasn't earning enough to even pay his rent, but I guess he thought he could buy time with the landlord, and hopefully his case would win in time. When I reviewed at that time, so we're talking late 2021, I reviewed the few months that he'd been working, and I determined that one of the months was above SGA. If you don't know what SGA is, look up one of the other videos. Probably the ones working while your claim is pending, which is something I like to help people do. So I spoke with him. I explained to him what he needed to do. You can't be working SGA and file a claim. So he did reduce his already very part-time hours to even less, so that he was under SGA. We did the appeal. Now I had a little bit of warning that he might be a procrastinator or not a great communicator because I couldn't get his updated medical information from him, and I had to appeal without it. I tried to drag little bits and pieces out later, or reordered records from the same doctors that I could later see were on his initial, assuming that he was still in the same network, and still going to the same doctor so I could get those updates. That's not ideal. I don't appreciate that kind of lack of participation by a claimant. And sometimes I will terminate the relationship in the middle of a case if I cannot get the person after months of trying to lift a finger in their own case. But that's another issue. So all's good. We appeal, however, non-ideally. And over the ensuing months, it would be hard to get information from him, but it would come in little pieces and after much nagging and stuff. So I get a phone call. We've been doing our side in the back, background, and hoping to further this case towards a reversal. And I get a message from the client that he's asked to call the field office to provide some information for his SSI. This is a concurrent case, SSI and SSD. And SSI, which is this federal welfare program, you can see the video on that, look it up. If you don't know what it is, it requires a financial interview after. It's called a perk. And that's so they can find out if you meet now that you've proven you meet the medical criteria of disability, do you meet the financial? So I was like, ding, 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 ding. Okay, they finally absorbed what we were saying and, agreed to their argument. So that's great. And then he drops the bomb on me that he's been working full time. Will that matter? Will that matter? You know, like, why do you think we had 2 hours of conversation last fall about you got to cut your hours below SGA? So sometimes it's like throwing your head into a brick wall, folks. Okay. So, oh my goodness. You have to then look at the full-time work, because there is nothing wrong with trying to work full-time. If you succeed, though, your case is over. If you don't succeed, that's called a failed work attempt. And generally that means if you worked for less than 6 months straight at the above SGA level, and you had to stop because of your medical disabilities, impairments, did not allow you to continue working at that level, that can be argued to be a failed work attempt. If it's over 6 months, and I mean to the day, no one's going to be discretionarily giving you a few days. Over that 6 months, your case is over. So it might just be miracles of miracles here that it was about 3 days short of 6 months. So if he's not able to continue, if he stopped in less than 6 months, this case may end up prevailing in his favor. But if it's over 6 months, he's screwed the pooch, as they say, because he didn't share any of this with me. So now maybe that's why he was avoiding talking to me. Sometimes people avoid communicating when they know they're hiding something. And let me just say, before we think someone's like a dishonest person, that's not it at all. It might not be the best reflection of honesty, but people generally are fearful, and some people, it's a mental crutch perhaps, stick their head in the sand and ignore what's going on so that they continue on their path. Gives them the most comfort and security in their head. Meanwhile, it's building up a big fire that's going to destroy them later. We can apply this to many areas of life, but when it comes to your Social Security disability case or SSI case, you cannot not tell your attorney. Like, had he told me this months before, I would have reiterated to him again and spent the hours reiterating what you cannot do. I know there was fear of being evicted without rent getting paid or partially paid. I get that. When you file a disability claim and you're not working and you can't meet your bills because you don't have a huge amount of savings, you have to downsize. You have to look at ways in which you're not going to have to pay rent, whether you're you can live with family, close friend, make it a month-to-month loan of shelter that you will pay back when you get back on your feet, win your case, win the lottery, whatever. But the SSA is not going to excuse the fact that you were able to work full-time or SGA because you needed to pay your bills. That's why we all work full-time. So you're not any different if you do that. And it shows that you're able to do it generally anyway. So don't hide what you're doing, thinking then it's never going to, if I don't say it, it just didn't happen. That's not true. Not only, you can be getting yourself in trouble in a multitude of ways. A, you might just not win your case, which is bad enough. But B, there comes a point where it could be considered, and I don't think at this early stage that's a danger. People are just clueless and fearful. And but if it came down to ever getting asked and you deny you're working, oh my gosh, that could be fraud against the government. That could be a multitude of things. And then also, if that happens and you have been receiving benefits and you haven't been clear and doing your duty of reporting, you could have a huge overpayment debt to the federal government for all those months of benefits you collected that you weren't supposed to collect because you were working so much. That's a big burden. Ask anybody who's dealing with an overpayment. And by the way, getting an attorney for that, probably not going to happen. So don't start working and not tell your lawyer, okay? I mean, they can troubleshoot it with you, figure out how long you can go, what you need to pull back on. It's just a sad situation when that happens. I'm hoping we have an avenue of saving this for him, because this person would not be able to work much full time, after which he stopped anyway because of medical problems. I mean, it was probably very medically unwise for him to do it. I understand one needs to pay their rent, take care of their critters, all that kind of stuff. But people have to start thinking outside the box when they're going to be filing for disability. It's similar to if you're going to be retiring with no work. Imagine that. Consider that if you're, 67, going to stop working, collect retirement, and live on that, you would be downsizing. You would be doing something probably to mitigate your costs. So it's not that different when you're just, filing for disability. You're just doing it earlier than you anticipated. And you got to do it because when you win, you're going to be living on only your Social Security, just as you would be at 67. So the same principles would generally apply. And of course, the exception is that we can work part-time, but there are limits and there are rules, and you can't ignore them, and you can't pretend you didn't hear about them and then go on and think it's going to be okay, because it's not going to be okay. All right. So take that home, pay attention, as always, keep learning, and always listen to your lawyer when they tell you how much you can work. Now, if a lawyer tells you you can't work, that's their way of being ultra conservative in terms of making it the strongest case to win. It's not always realistic, though. That's why I help people who say they have to work, and we figure out how they can do that with the least amount of risk to their pending claim. Or if they are already collecting, the definite rules they have to adhere to, or else they will end up losing their disability. Okay. All right. Tally ho, and have a great week. And I will see you next time. You know how to reach me. Stephanie Joy at joydisability.com. Thanks so much. Bye-bye now.